NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice. Okay, I think we can go ahead and get started. Thank you for joining us and welcome to Roadmap to a Representative Jury. I'm Monica Milton, Public Defense Counsel for the National Association of Criminal Defense Lawyers. This webinar is being conducted as a part of the Justice for All Strengthening the Sixth Amendment grant. Partnering with NACDL on this webinar and this grant is the Association of Prosecuting Attorneys, the National Center for State Courts, and Research Triangle Institute International. Before I introduce our speakers, here are some general housekeeping rules. As you may have noticed, everyone but the panelists and moderator are automatically muted and their cameras are turned off. Questions for panelists, we ask that you use the Q&A function. And if you have questions involving tech issues, we ask that you use the chat function. And you can also use the chat function to chat amongst yourselves and say, where you're joining us from. We'll be monitoring the messages and we'll do our best to get to as many questions as we can. This program is being recorded and will be made available on our website for future viewing and sharing outside of our paywall. CLE credit is available for this training, and we will take a brief pause to announce the code, place it on screen, and put it in the chat. CLE forms will also be emailed after the program is complete. So I'm going to give an abbreviated introduction to our esteemed panel, but I encourage you all to take a look at their full bios on our registration page. Emily Coward serves as the Director of Inclusive Juries Project with the Center for Criminal Justice and Professional Responsibility at Duke University School of Law. From 2012 to 2021, Emily was an attorney with the UNC School of Government's Public Defense Education Group, serving as Director and Project Attorney of the North Carolina Racial Equity Network. She was awarded the UNC School of Government Margaret Taylor Writing Award for co-authoring Raising Issues of Race in North Carolina Criminal Cases and the James E. Williams Award for the North Carolina Public Defenders Association. She currently serves as chair of the Data Study and Evaluation Team of the NC Governor's Task Force for Racial Equity in Criminal Justice and a commissioner on the North Carolina Commission on Racial and Ethnic Disparities in the Criminal Justice System. Nina Chernoff is professor at CUNY School of Law. Professor Chernoff's research focuses on the jury, primarily the right to a jury selected from a fair cross-section of the community. Her article, No Records, No Right, Discovery and the Fair Cross-Section Guarantee, was cited by the Iowa Supreme Court in State v. Plain in support of a constitutional right to discovery of jury selection records. And it was also featured on Last Week Tonight with John Oliver. Her article, Wrong About the Right, How Courts Undermine the Fair Cross-Section Guarantee by Confusing It with Equal Protection, was featured by the Getting Scholarship into Courts project of the National Association of Criminal Defense Lawyers. Honorable Joseph Crosswhite was elected as North Carolina Superior Court Judge in 2008. In February 2012, he was appointed as Senior Resident Superior Court Judge for Judicial District 22A by Chief Justice Sarah Parker. And in 2016, he was elected President of the North Carolina Conference of Superior Court Judges. He currently serves on the Pattern Jury Committee and as a Commissioner on Indigent Defense Services. Anita Earls is Associate Justice of North Carolina Supreme Court. Before taking office on January 1st, 2019, she was a civil rights attorney litigating voting rights, police misconduct, and other civil rights cases for 30 years. Anita was the founder and executive director of the Southern Coalition for Justice, a nonprofit legal advocacy organization in Durham, North Carolina. Appointed by President Clinton, Anita was a Deputy Assistant Attorney General in the U.S. Department of Justice Civil Rights Division from 1998 to 2000. She has served on the North Carolina State Board of Elections, the North Carolina Equal Access to Justice Commission, and currently co-chairs the Governor's Task Force on Racial Equity and Criminal Justice. Anita has taught as an adjunct professor at UNC and University of Maryland School of Law and the African American Studies Department at Duke University. Mark Kleinschmidt has served as the elected clerk of Superior Court for Orange County, North Carolina since December 2018. As clerk, he serves as the judge of probate, the court's financial officer, and the keeper of the record of all state court activities in Orange County. Among his duties is to call citizens of Orange County for jury service. District Attorney Spencer B. Merriweather III has served as the chief prosecutor at Mecklenburg County since 2017. DA Merriweather removed financial barriers that prevented some defendants from participating in deferred prosecution programs, and he broadened referrals to treatment programs. He established a violent crimes team, which focuses on shootings and felony assaults, and a special victims team, a group of trauma-informed prosecutors and staff who seek justice for adult and child survivors of sexual assault and domestic violence. DA Merriweather is actively involved in efforts to establish a family justice center in Mecklenburg County to serve survivors of domestic violence, child abuse, elder abuse, and sexual assault and human trafficking. And last but not least, we have Assistant Clerk of the Superior Court in Iredell County, Ruth Prevette. She has been with the clerk's office for 25 years, was appointed to Assistant Clerk in 2006, and named Senior Assistant in 2012. She has been the jury clerk since 2004. So with all of those this great panel we have, I'm pleased to introduce Professor Chernow so she can begin with her fair cross-section presentation.
Thank you, Monica. And I'm so appreciative of the opportunity to be a participant on this panel with such an illustrious group. And I'm also grateful to be in a community, even virtual, with people who are interested in, invested in, curious about making our juries more diverse. So in this presentation, and allow me to share my screen. Somebody shout at me if you can't see it. In this presentation, I'll address why exactly jury diversity matters so much, why it's worth all of our efforts to achieve it, as well as the legal framework for challenging juries that fail to represent the community and that they fail to represent people of color. And I'm going to focus here on the right to a jury selected from a fair cross-section of the community. And then I'll describe some of the ways that the invisible stages of jury selection can interfere with our ability to attain that fair cross-section goal. So those invisible steps that interfere with our ability to assemble a diverse group won't be a surprise to some of you who are enmeshed in the jury selection process, but for many of us, they are a bit of a surprise because they take place kind of behind the scenes. And yet that's where so much of the action happens when it comes to who's showing up at the courthouse, who's available to sit on a jury. And I'll close by identifying some possible next steps for North Carolina. But in case you can't stay for the full presentation, or that feels like more information about the jury than you're really invested in, I want to jump to the punchline, which is the issue of jury diversity. It's not an intractable problem, and states can make changes, concrete, sometimes small, sometimes administrative policy changes that can increase the diversity of the jurors who are deciding cases in their jurisdiction. So I'd ask you to picture a courtroom in North Carolina. We have a Black man who's charged with a criminal offense, and he's facing an all-white jury. And I want you to just think for a moment about what problems does that pose? What problems does that pose for the defendant? Maybe what problems does that pose for the community where the trial is occurring? What problems does it pose for the court? You probably don't need that much time to think about it. Just want you to sort of have those in your mind. One problem that may have come to mind, just thinking about that, is the risk that the community won't trust whatever verdict that jury reaches. And this is one of the reasons that jury diversity matters so much, because it turns out that people's confidence in the verdicts reached by courts really depends on the diversity of the jury that reached that verdict. So one example of this, there are many, but one example of this link between jury diversity and public confidence in the verdict reached by that jury comes from a study of more than 300 jury eligible individuals. And this study used a hypo of a Black man who was charged with shoplifting. And all of the respondents were asked to read about the trial, read about the verdict, and then rate the verdict as fair or unfair. But the researchers tested 4 different versions of this hypo. In half of the hypos, the defendant was acquitted, and in half he was convicted. And in some of the hypos, the jury was described as being all white. And in some of the hypos, the jury was described as being racially mixed. And here's what they found. When the jury was racially mixed, people rated an acquittal and a conviction as equally fair. In other words, the racially mixed jury was seen as a fair enough process that any outcome was seen as fair. But when the jury was all white, people rated a conviction as significantly less fair. So in other words, when the jury was all white, the respondents didn't trust the outcome where the government prevailed over the defendant. And this issue, the fairness of the criminal justice system, is at the forefront of many of our minds at this moment. We're at a point in history where the majority of both Black people and white people in the US believe that Blacks are treated less fairly than whites by the criminal justice system. So that opinion, there's a higher percentage of Black people in the US who feel that way, but the majority of both Black and white people believe that Black people are treated less fairly. And similarly, in 2015, diving down to North Carolina, a survey found that 48% of North Carolina residents believe that whites receive better treatment than others in North Carolina courts. So that's one problem. And here I'm describing the problem using the words of the North Carolina Task Force for Racial Equity and Criminal Justice. One problem when we have the underrepresentation of communities of color on the makeup of jury panels is that it degrades public trust in the criminal justice system. Now, another problem that might have come to mind when you were thinking about that Black defendant facing an all-white jury is the risk that their verdict could be tainted by racial bias. And indeed, the data shows that verdicts of more diverse juries are less likely to be corrupted by racial bias. So this demonstrates that the increased public confidence in the verdicts reached by diverse juries is well placed because their verdicts are less likely to be biased. One of the most thorough studies of this phenomenon was a study of 785 felony trials in Florida over a 10-year period. And this study was conducted by economists at Duke University. So the study looked at juries that were drawn from an all-white jury veneer. And in this study, veneer referred to the group of about 27 people from which individual pettit juries were chosen. So the study compared juries that were drawn from that all-white group to juries that were drawn from a veneer that included at least one Black person. And what they found over 700 trials was that juries that were drawn from an all-white group convicted Black and white defendants at significantly different rates. Those all-white juries convicted 81% of Black defendants, but 66% of white defendants. And this racial disparity essentially disappeared from juries that were selected from a veneer that included even one Black person. On those juries, the conviction rate was roughly equal, 71% to 73%. So this led the researchers to conclude that the Black-white conviction gap declined in all trials where there is at least one Black member of the jury pool. And we see a similar result of conviction rates differing by race, depending on the makeup of the jury pool, from a North Carolina study. So this was a study of 737 felony trials in North Carolina between 2010 and 2012. And the study looked at the conviction rate for Black defendants. And the two comparison points were, the study looked at juries where white men were a smaller percentage of the jury. So they were less than 22% of the jury pool. And the study compared the conviction rates produced by those juries to the conviction rates of juries that had more white men, that included more than 39% of the jury pool. And what they found is that when white men made up a smaller percentage of the jury pool, the conviction rate for Black defendants was 70%. But when the percentage of white men in the jury pool increased, the conviction rate for Black defendants also increased up to 82%. What's particularly interesting, going back to the Florida study for a moment, so both these studies show that we're getting verdicts dissimilar based on the defendant's race, depending on the diversity or lack thereof of the jury pool. But what's also interesting about the Florida study is in that jurisdiction, African Americans made up only 4% of the population. And so the study demonstrated, and I'm quoting from the researchers now, that even small changes in the composition of the jury pool could have a large impact on fairness. That is, a large impact on the disparity between average conviction rates for white and Black defendants. And I think this is worth highlighting because some of the changes that could be made in North Carolina might have only a small impact when we're talking about raw numbers, but small raw numbers changes can have a big impact on equity of verdicts and fairness in verdicts. So I think of that as helpful motivation. Now, again, when you were thinking about this courtroom, North Carolina, Black defendant facing an all-white jury, you may have also thought about the kind of deliberations that the jury was going to engage in. When they get into the deliberation room, what kind of conversation is this all-white group going to have? What are they missing? What are they focused on? And this turns out to be the third reason that jury diversity matters. And another reason that it's appropriate that there's more public confidence in the verdicts reached by diverse juries, because there's empirical data showing that the quality of deliberations is higher when the jury is diverse as compared to the quality of deliberations when the jury is all white. This data comes from a series of studies conducted by Dr. Samuel Summers that compared the deliberation process of 6-person juries, compared the deliberation process of all white 6-person juries with the deliberation process of juries that included 4 white people and 2 Black people. And what they found was that compared to the all white juries, the racially mixed juries deliberated for longer. They discussed a wider range of evidence. That is, they discussed more case facts. They made fewer factual errors, and they were more likely to correct the factual errors when they were made. And they were more likely to discuss racial issues such as racial profiling. And what's particularly interesting about these studies is that it was really the behavior of the white jurors that changed. This wasn't a case of the Black person in the room being responsible for or having, feeling responsible for sharing certain perspective. The behavior of white jurors changed. So this chart, I know it's sometimes hard to take in information from a chart on a Zoom, but this chart is comparing the behavior of white jurors who are part of an all-white group and comparing that to the behavior of white jurors who are in a diverse group. And you can see that the white jurors on the diverse group themselves raised more case facts, made fewer factual errors, and raised more race-related issues. So, for example, you can see that white jurors on diverse juries made about 4 factual errors versus white jurors on all white juries made about 7 factual errors. And this led the researchers to conclude that jury representativeness can be more than a moral or constitutional ideal. It's sometimes an ingredient for superior performance, that juries are better at doing the very thing we are asking them to do. The trouble is that even though the data and for some of us, our life experiences suggest to us that the system works better and is trusted more if juries are diverse, across the country, jury pools are disproportionately white. And that overrepresentation of white people in jury pools nationally is unfolding against the reality that's true in North Carolina, as well as nationwide, that people of color are disproportionately represented in the pool of criminal defendants. So we have this mismatch, and it can be hard to track down the specifics about this data, that disproportionate representation of white people in jury pools. The most recent national data from jury pools in the federal courts found that underrepresentation of Latino and African American populations is ubiquitous. Specifically, the study found that 40% of African Americans are not part of their community's federal jury pool. And 30% of Latinx people are not part of their community's federal jury pool. So what about North Carolina? How representative are the North Carolina jury pools? The short answer is we don't know, because there's not data yet collected on that issue. So we can't answer that question. And that's presumably why one of the task force recommendations is to enact a statute that mandates the collection of jury data and makes that data available as a public record, excluding any personally identifying information, of course. The task force also recommends that the Division of Motor Vehicles includes race data on the jury list in order to monitor compliance with the fair cross-section guarantee. We, of course, can't know whether the jury pool is representative, that is, whether we're fulfilling constitutional obligations, unless we have that data. But this is my chance to ask you, a group of interested North Carolinians, is that the North Carolinians with expertise about how well, in your opinion, do juries represent their communities here? Across the state, Black people make up 22% of North Carolina's population, but in some counties like Durham County, Black people make up 37% of the population, and there are other counties where Black people make up more than half of the county's population. So we're going to do a poll now, if you will care to participate. So Randy, if you could launch the first poll. Just curious, in your opinion, and obviously we don't know what you're drawing your opinion from, but how often do the juries in your jurisdiction reflect the diversity of that community? Almost always, frequently, sometimes, or almost never. And I'm seeing an indicator, fellow panelists, that you are not permitted to vote. So I apologize. I am interested in your opinion, but. Okay, interesting. So 63%, the majority say sometimes, 30% say almost never. Obviously, you know, that I appreciate hearing your perspective. We can't be sure. It's certainly, North Carolina would be in, I don't know if good company is the phrase, but in crowded company, if the jury pools do fail to fully reflect the diversity of the communities. That's a national problem that we're seeing across the country. The one good thing about the fact that this is an issue that so many jurisdictions are struggling with is, as I'm about to highlight, there are a lot of jurisdictions that are making attempts to solve this problem, and we can learn from and adopt some of the best practices that other jurisdictions have adopted. We know that jury diversity matters, or the statistics tell us that jury diversity matters, and we're not sure how well North Carolina juries reflect their communities, but there's some suggestion that maybe we could do a little bit better. So this brings us to the legal standard. You know, what does the law have to say about this? And specifically with the fair cross-section right. So let me ask you, while we got the polls going, another question. So Randy, if you could launch poll 2. If a jury system, this is anonymous, by the way. So if a jury system underrepresents people of color, but there is no discrimination at any stage, can there be a constitutional violation? Okay, great. 80% said there still can be a constitutional violation. And that is correct, but it's sort of an under the radar fact. There can still be a constitutional violation. And that's because there are 2 constitutional rights that apply to the jury selection process, 2 key ones. And the first one that usually pops to mind for most of us is equal protection. So that's the right to equal protection of the law. It is a prohibition on intentional discrimination. So it prohibits states from engaging in intentional discrimination. It's housed in the 14th Amendment, which, as you know, was passed after the abolition of slavery in an attempt to address racial discrimination. The right to equal protection applies to every stage of the jury selection process, and it applies in civil and criminal cases. So that means, given that the equal protection right applies to every stage of the process, that it would be unconstitutional for example, for the jury clerk to engage in discrimination in selecting juror names for the source list. And it's also unconstitutional, that is a violation of equal protection, for an attorney to engage in discriminatory peremptory strikes. And if there's no discrimination, then there's no equal protection violation. But there can still be a constitutional violation, as 80% of you recognize, and that's because there's also a constitutional right to a jury selected from a fair cross-section of the community. So this right is housed in the Sixth Amendment of the Federal Constitution and Article 1 of the North Carolina Constitution. And like all Sixth Amendment rights, it applies only to criminal prosecutions. And I want to highlight 3 aspects of the fair cross-section right that make it totally different from the right to equal protection. The first thing to note is that the fair cross-section right, in contrast to equal protection, does not apply to every stage of the jury selection process. So this brings us to our next poll question. Which stage of the jury selection process does not need to include a fair cross-section of the community? So Randy, if you could, great. Randy's like, I read your name. Which stage does not need to include a fair cross-section of the community? Okay, interesting. So most people identify the correct answer, which is the jurors on the individual jury do not need to represent a fair cross-section of the community. But we see some other answers, which is very common. I think this is why I sort of describe these as some of the invisible stages of the jury selection process. And it's not always completely clear in our heads, these distinctions between equal protection and fair cross-section. So the answer is that the fair cross-section right applies to all stages of jury selection before voir dire. So the fair cross-section right applies to the selection of source lists, the decision about who's qualified, the decisions that courts and states make about how to summons jurors, how to respond to jurors when summons are issued, and the veneer, which I'm not sure if that's the word that you use in North Carolina, but I'm using it to describe the group of people who arrive at the courthouse on a given day, ready to participate in jury selection, even though some of them will end up on a jury. The fair cross-section right does not apply to voir dire. So it does not apply to for-cause challenges, to peremptory strikes, or to the actual jury that decides the case. So I think it's fair to say that the fair cross-section right doesn't guarantee you a representative group of people to decide your case, but it guarantees you a chance to obtain a representative individual jury by making sure that every stage of jury selection before voir dire includes a representative group of the community. The second important point to highlight about the fair cross-section right is that discrimination is irrelevant. The Sixth Amendment, as you know, is focused on protecting the individual from overreach by the government, and it was not related to discrimination. And unlike other constitutional amendments, it is not a directive to refrain from doing something. It's an affirmative obligation. We have to affirmatively produce something that is a attorney for a defendant, a speedy trial, and a jury that reflects a fair cross-section of the community. And the Sixth Amendment doesn't care if the reason we're failing to produce that representative jury pool is discrimination or the application of completely race-neutral policies. And that brings us to the third point that I want to highlight about the fair cross-section right. Entirely race-neutral policies, entirely benign policies, can lead to the type of systematic exclusion that violates the Sixth Amendment. And why is that? It's because when someone is seeking to make out a claim that their fair cross-section right has been violated, they have to prove 3 things. The first is they have to identify a distinctive group in the community, such as African Americans. And second, the person trying to make out the fair cross-section claim has to show that the representation of that group is not fair and reasonable when you compare the representation of the group in the jury pool to the representation of that group in the community. And the third thing, this is the key, is the parties trying to make out the fair cross-section claim has to show that the reason the representation is unfair or unreasonable is caused by systematic exclusion. In the words of the Supreme Court, it's caused by something inherent in the jury selection system. And again, this inherent issue can be race neutral, it can be non-discriminatory, but if it is a component of the jury selection process that's resulting in a jury pool that fails to reflect the community, that constitutes systematic exclusion. So the question that comes up in this context is, when is disparity actually attributable to something inherent in the jury selection system? Or what are these invisible or inherent aspects of jury selection that can lead to disparity in the jury pool? Because there's a sense often that the factors that reduce diversity in the jury system are factors that are just outside of the control of courts. But as I'll discuss in a moment, the good news is that there is a great deal that courts and states can do to increase racial and ethnic diversity on juries. And some of the things that might feel the most out of the court's control, such as undeliverable rates of jury mailings or non-response rates by jurors or jurors' failure to appear, or the rate that jurors seek excusals. According to the National Center for State Courts, these are the components of jury yield that offer the most potential for effective control. So that's the good news. Things that feel like they're outside of our control can be changed with policy changes. So that brings us to the third sort of component here of this presentation, which is, so what are they? What are these inherent invisible aspects of jury selection that can lead to unrepresentative juries? And again, this is the good news I mentioned, that this is the reality that states can make changes to increase diversity. But I want to ask you your opinion first. Which of these steps is most likely to increase jury diversity in North Carolina? So I see the poll is now launched. Okay, interesting. So using the public benefits list as one of the sources for jury names, 38%, updating addresses more frequently, educating people in the community, and increasing pay. Okay, great. So there's data to support some of those, not others. Some things just haven't been studied yet, but I'll share with you what we do know. So again, I picture this in terms of there are these invisible stages of jury selection and visible stages. And again, the visible stages, like if a lawyer strikes a juror, if they strike every person of color in the jury box, we can see that. The parties see that, the judge sees that. If there's any reporters in the courtroom, they see that. But most of us don't see these invisible stages that produce the jurors. And so I want to highlight 4 policy choices at these invisible stages of jury selection that have the power to change the diversity of the juries we end up with. I like to think of it as this funnel, and that people get filtered out as the process goes on. So the first of these invisible stages is the selection of source lists. So this is the choice about which lists from which state agencies should become the source for potential juror names. And this is an important policy decision because, to state the obvious, the jury system is never going to get more diverse than the source list selected. If your name is not on the source list, you're never going to enter the jury pool. And North Carolina uses the list of registered voters and the list of licensed drivers. So is that a good list combo? It depends. We don't know because we don't have data on the racial and ethnic makeup of those lists. And it depends, and it varies by state, whether the list of registered voters and licensed drivers actually represents the community. In some states where we do have the data, we can see sometimes surprising disparities or differences between the number of licensed drivers or registered voters that varies by race and ethnicity in dramatic ways. And at least nationally, we have data that shows that rates of possessing a government-issued photo ID vary by race and ethnicity. So nationally, only 5% of white people lack a photo ID, but that number is 13% for Black people and 10% for Hispanic or Latinx people. In addition, people who make less than $25,000 a year, 12% of that population lacks a photo ID compared to only 2% of the population that makes more than $150,000. So what kind of policy decisions at this stage would increase diversity on the jury? Using representative source lists. Sometimes people talk about this, about using multiple source lists. Multiple source lists is only important to the extent that it makes this, the jury more representative. If a state has one list that really includes the full community, then you only need one list. It's not so much about how many a state uses, but how comprehensively and completely those lists reflect the community. One possible list is the income tax list. So this was just added as a source list in 2021 by California and Connecticut. And there's a number of states listed on this slide that use that list. And then our top proposal from our opinion poll was adding the list of people who receive public benefits. That was recently added by Connecticut and has been a source list in a number of different states. This is connects with one of the task force recommendations, which is that North Carolina should increase representation on juries by expanding the source list to ensure that more people get included in the jury pool at the start. And the task force recommended people holding state ID cards, so non-drivers IDs. And in some states, the racial differences between non-driver IDs and driver's licenses is significant. And at least one state has improved jury diversity just by adding the non-driver's ID. So a second list from the same state entity. Also, people receiving public assistance, that's the one we flagged in the poll, or applying for unemployment, telephone directories, utility lists, the list of newly naturalized citizens, or the list of income tax filers. And one of the benefits of some of these lists is that they're updated more frequently than voter registration or motor vehicle lists. So the tax list, for example, is updated every year. So we're more likely to have accurate contact information if we're using some of these other lists. And the good news is that existing North Carolina statute allows for the addition of other lists, because the statute says that the jury commission can use other sources of names that it deems to be reliable. So this change could be made without any legislative changes. Another invisible stage of jury selection that really has the power to affect the diversity of the group of people who arrive at the courthouse is the question about who's eligible to serve as a juror. And in most states, including North Carolina, this is set by statute. These eligibility criteria can have a significant impact on diversity. So, for example, North Carolina excludes people with felony convictions who have not completed their period of community supervision, their probation or parole. And we know that right now there are about 56,000 people with felony convictions in North Carolina, 42% of whom are African American. So a disproportionate percentage of that group of people is African American. And as the court in Community Success Initiative versus Moore recently recognized, and this is in the context of voting, not jury service, that African American men in North Carolina make up only 9% of the voting age population, but make up 36% of the population excluded from voting because of a felony conviction. Now, it's true that North Carolina allows people who have a felony conviction to participate in jury service once their period of supervision, their probation or parole is completed, but some states exclude only people who are currently incarcerated. So Colorado, Illinois, Iowa, Indiana, North Dakota, all exclude only people who are currently incarcerated. And that's a shift that would make a big difference when you look at the numbers in North Carolina, because there are 55,000 people in prison or jail in North Carolina, and there are 91,000 people on community supervision. So if roughly 45% of those 91,000 people are African American, then adding those people to the jury rolls has the potential certainly to increase the diversity of the jury pools. Another eligibility requirement that most of us, I would guess, maybe hadn't thought about is the requirement that people be citizens. And this is connected to the idea that we want jurors to be invested and connected and sort of permanently connected to our community so that they have the right investment in the process. But a closer look at the immigration rules reveals that there's another group, lawful permanent residents, who are very similar to citizens in terms of their status and their permanence and the legality of their the documentation of their presence. And this is a group that could be added, and that has potential to add a lot of diversity. So nationally, 37% of the adult Hispanic population are not citizens, and 33% of the adult Asian population. Now, some, but not all of these people are lawful permanent residents. And Connecticut, which enacted some significant jury changes in 2021 in a direct effort to increase jury diversity, added lawful permanent residents in addition to citizens to be eligible for jury service. And in North Carolina, that would add more than 100,000 people to the jury rolls and has the potential to really add some diversity. So what kind of decisions at this stage, the stage where we decide who's qualified, could improve diversity? Limiting the felony exclusion only to people who are incarcerated and including lawful permanent residents. A third invisible stage of jury selection that can affect the diversity of the juries is the administrative decision about how often to update the addresses for the people on the jury lists. Nationally, 13% of all jury-related mailings are returned as undeliverable. So the post office sends out the jury summons and then brings it back to the courthouse saying, this is undeliverable. The person is no longer at this address. And this can have a big impact on jury diversity because nationally, the undeliverable rate is higher in communities of color. And this is because this is the product of systemic racism. So we now have a correlation between race and home ownership. So as you can see from this chart, which illustrates national data, home ownership rates for whites are higher than for other racial and ethnic populations. In North Carolina, for example, the home ownership rate for white households is 75%. But the Hispanic and Black home ownership rates are significantly lower. It's 48.2% for Hispanic households in the state and 45.6% for Black households in the state. Okay, so how does this connect to address updates? People who own their home are less likely to move than people who rent. So this data illustrates nationally over time, the percentage of renters who switch addresses is always higher than the percentage of homeowners who switch addresses. And that means that people of color, if they have lower home ownership rates in the state, are more likely to move than white households. And indeed, national data illustrated here shows that the national mover rate for the white population is lower than for the Black population, the Latino population, and the Asian population. So to tie all this together, when a jury office updates addresses less frequently, it ends up with more inaccurate addresses. And therefore, it's going to end up with less diverse juries because those inaccurate addresses are going to be disproportionately high in communities of color in contrast to white households. So what kind of decision at this stage would help improve jury diversity? Updating addresses more often, or using source lists that themselves have more frequently updated addresses. North Carolina updates its list every 2 years, and one of the task force recommendations is that the list be updated at least annually rather than every 2 years, and also taking other steps to correct addresses to reduce this problem of undeliverable summons, because high undeliverables means low diversity. The annual update is consistent with the perspective of national experts, including the American Bar Association Commission on the Jury, which produced principles for juries and jury trials, one of which is that source lists should be updated at least annually. And the at least part is important because it gives room to follow the recommendation of the National Center for State Courts, which is if a court is located in a state or a metropolitan area with a higher than average migration rate, they should consider updating their lists even more frequently, like semi-annually or quarterly. The key is you want to be able to keep up with the residential mobility rate of the people who you're trying to summons for jury service. The fourth invisible stage of jury selection, or the fourth, there's multiple, I'm just talking about 4 today. The fourth decision that can affect diversity is the decision of how much to pay jurors for their service, and a related decision about how long jury service should last. Because jury service imposes an economic hardship, and this affects jury diversity because, again, because of systemic racism, race and ethnicity are correlated with income in our country. So in North Carolina, trial jurors receive $12 for the first day of service. They receive $20 for every day after that, and if they serve for more than 5 days, they receive $40. So that's a race-neutral policy, but it has a disparate effect, as is true in other states, because of the socioeconomic realities of the state. So in North Carolina, 9.8% of the white population lives below the poverty line. That's in contrast to more than 20% of the Black, Latino, or Latinx and American Indian population. So that $12 a day is going to land differently for different populations. And this is particularly true not only because people with less income are less able to afford the time away from work, but also people who have low income jobs are less likely to be paid by their employer for jury service than are people who are paid more. So it's sort of a double layer that makes it a bigger loss for poor people to serve as jurors. So what kind of decision here could improve jury diversity? Raising the amount of jury pay and decreasing the length of service, which together, again, impose the financial burden. This is an older example of the kind of difference that an increase in juror pay can make. This is El Paso, Texas. they increased their jury pay from $6 to $40. This was 20 years ago. So 20 years ago it was $40. But when they did that, public participation in jury service jumped from 22% to 46% within 1 year. And eventually the show-up rate climbed to 60%. Now, a more recent example comes from California, where they just established in San Francisco a pilot program to pay low-income trial jurors $100 a day to see if they're studying whether that will have an effect on improving the diversity of the jury pool, which is their goal. And consistent with this, the task force recommended increasing juror pay, as well as considering offering childcare, because that's obviously a related financial burden of jury service. And this recommendation by the task force is consistent with the acknowledgement of the American Bar Association that excusals from jury service because of economic hardship reduce representation. So people have to be paid a reasonable fee. And similarly, the National Center for State Courts has recognized this relationship between the amount of the jury fee and minority representation in the jury pool. So what are the possible next steps for North Carolina? This is, not an exhaustive list what I've talked about today, and I'm really interested to hear more from my fellow panelists and the audience about other ideas. But again, I just want to emphasize that there is a great deal that courts can do. Some of these changes will make, again, small numerical changes, but small numerical changes in the diversity of the jury pool can have a big impact on the equity of verdicts and the confidence with which the public views the work of the court. So the recommendations for achieving jury diversity, including making sure that source lists are representative. So this entails both knowing whether they are representative, and then if they're not representative, adding other lists. The second recommendation is to change the eligibility requirements to admit more people to jury service by limiting felony exclusions to those people who are incarcerated and possibly adding lawful permanent residents in addition to citizens to the jury rolls. The third recommendation is to update addresses more often or to use source lists that have addresses that are more frequently updated to make it more likely that a jury summons will actually reach the person that we're trying to summons. And finally, increase the rate of jury pay so that it makes it possible for low-income people to serve. And now I just have one last question for this group. If we were choosing among these policy changes, which do you think should be our top priority? Randy, can you launch that last poll? Okay, interesting. So adding source lists and updating addresses are the two top contenders. So that's one of the, there's plenty of questions for the panelists, but one of the things I'm curious about is what would that take? What do we need to do? What are the source lists that would be best in this state? What are the ways we can get those more accurate addresses? In any event, I appreciate so much the chance to talk with you. I'm really looking forward to hearing from the other speakers and if there's comments and observations from the audience participants as well. So thank you so much.
Thank you so much, Professor Chernoff. That was fantastic. I learned so much every time you come to North Carolina in person or virtually to share your expertise with us. I am joining you all today from Duke University School of Law, the Inclusive Juries Project. That if you have not heard of it, it is because it launched this week, and I am thrilled to do more of this work around jury diversity, inclusive juries in North Carolina and beyond. And while Professor Chernoff did an excellent job explaining all the ways in which we can encounter problems in our quest to guarantee diverse and inclusive juries, I also am really pleased to have so many dedicated public servants with us today who are taking steps every day to ensure that we do in fact guarantee a fair cross-section in this state. As Professor Chernoff noted, we don't have the data to answer the sorts of questions that were raised. We do have suggestions that using only driver and voter source lists, as we do in North Carolina, doesn't always adequately capture the full diversity of our communities. In Nebraska, for example, that also uses driver and voter data lists to comprise their master jury lists. We know that people of color were very underrepresented in a study that looked at the inclusivity of those lists. So we have reason to be concerned. And I am currently involved in trying to collect the data from the DMV and merge it with the voter data that we have publicly accessible, to actually answer those questions and to be able to share with the public on a county by county basis just how inclusive our jury pools are. So work is underway on many fronts. Much of that work is being conducted by people who are joining us today. And so I really am excited to bring you all into the conversation and learn about what you see on the ground, what steps you're taking to ensure jury diversity in this state. And I'm going to start by bringing Justice Earls into the conversation. As we heard in Professor Chernoff's presentation, there are extensive recommendations in the Governor's Task Force for Racial Equity and Criminal Justice that is co-chaired by Justice Earls that pertain to these issues. Recommendation 91 is really the one that centers on the fair cross-section issues. And Justice Earls, thank you so much for joining us today. I would love to hear from you about the purpose of the Governor's Task Force recommendation around fair cross-section reforms, why you believe it is needed, and what you hope those potential reforms may accomplish in North Carolina.
Yes, well, good afternoon, and thank you so much for including me in this amazing program. I will just say that our task force focus, because we are about racial equity and criminal justice, not only the fair cross-section aspects, which, as you point out, are addressed in one of the recommendations, but also the equal protection issues. And I want to start by saying that a lot of the information that was presented about why it's so important to have diverse juries is also now, I would submit, part of the precedent of our state courts. The Supreme Court earlier this year in State versus Clegg, laid out the reasons why racial discrimination in jury selection is so harmful, talking not only about the harm to the individual defendant, the harm to the excluded juror who is unduly denied the civic responsibility and opportunity of jury participating, but we also identified the harm to the entire community and stated, in short, racial discrimination in jury selection is at war with our basic concepts of a democratic society and a representative government. So our court is now on record explaining the importance of eliminating racial discrimination in jury selection. And I also want to, by way of laying context, remind us that in the Batson decision itself, Justice Marshall actually concurred with a concurring opinion in which he said 3 different times very explicitly that the decision today will not end the racial discrimination that peremptory challenges inject into the jury selection process. That goal can be accomplished only by eliminating peremptory challenges entirely. Now, the task force didn't go that far, but I think his insight 36 years ago, I wish I could say that that was something he was wrong about, but sadly, I don't think we can. And so that part of the jury selection process that we haven't talked about so far, what happens in the courtroom when peremptory challenges are being used, is also something that our task force addressed. So with recommendation 92, we suggested that we focus on outcomes over intent, and we particularly pointed to the Washington State Supreme Court that has adopted a rule that eliminates the Batson framework, eliminates the requirement to show a prima facie case of discrimination before a challenge can be sustained to the use of a peremptory challenge. And that rule actually identifies some facially race neutral reasons for excluding jurors that actually might be hiding racial bias, including implicit racial bias. So I would lift up Washington State's Rule 37 as a potential model that the task force found useful in addressing the problem of peremptory challenges. We also talked about the need to have implicit bias training to all jury system actors, so that jurors get instruction on what implicit bias is and how it implicates their decision making. And we recommend that there be a state commission on the jury system that can look comprehensively across the state at both these fair cross-section issues, how are we compiling our jury lists, but also what's happening in the courtroom with the use of peremptory strikes. So those are some of the things that the task force thought might get us closer towards eliminating all forms of discrimination in jury selection in North Carolina.
Thank you so much, Justice Earls, and I really appreciate you zooming out to include all of these other essential components of ensuring that we have fair and impartial juries in North Carolina. This, while the series is focusing on the Sixth Amendment rights and the fair cross-section guarantee that can sometimes get short shrift in discussions around jury inclusivity. There's, I think, been historically, both in litigation and in training, a focus on Batson, which hasn't necessarily translated into the full recognition of the right to be free of racial discrimination in jury selection. But I think that it's really one of the strengths of the task force recommendations that it is so holistic and inclusive around looking at all of the different factors that contribute to whether or not you ultimately have not just a representative jury pool, but a representative and inclusive and non-discriminatory seated jury. And I think that it's important. It was just posted in the chat, and I hope you will all take a look. Just this week, the task force released suggested jury practices. So as you may know, the task force works on implementing the recommendations on multiple fronts: legislative, judicial, local policy, administrative. And the task force has recommended the use of a number of different model policies that are related to the recommendations adopted by the task force. So I worked in partnership with the task force on putting together suggested local jury practices for district and superior court judges that the task force believes would help advance the cause of would help advance the goals that are reflected in the jury recommendations adopted by the task force. These were just released this week. I hope to build out some educational programs for judges who are interested in learning more about these practices. They include things like adding additional source lists. Of course, that's a jury commission decision, but it is up to the senior resident superior court judge to do things like decide to update the list annually instead of every other year. It's a very comprehensive document that we hope you will take back to your communities and learn from, give us feedback on, and it really goes to Professor Chernoff's point that there are some statutory changes that could be helpful in guaranteeing jury diversity, but there are also some steps that can be taken right now, just in local practices, that could also really advance this goal of making sure that we have representative, inclusive juries. And so this document includes both fair cross-section and equal protection issues, as well as concerns about addressing juror bias. And to that point, I'm just going to post in the chat, before bringing our next panelist into the conversation, a juror video that can be used in jury orientation addressing implicit bias, I believe. And when we get to speaking with DA Merriweather, you can confirm this, that this is in use or will be in use in September in Mecklenburg County in jury orientation, and has been used in other counties across the state. It was just released earlier this year. But I also want to broaden the discussion. There are more than just members of the task force and partners with the task force working on these issues. And I really want to bring Deontay Thomas, who is Chief Public Defender in Wake County, into the conversation to tell us about the work of the Jury Fairness Committee that is a part of the Chief Justice's Commission on Fairness and Equity. What are the primary concerns of this committee? What has it done so far? And what do you expect? What issues do you expect it to take up in the future?
Thank you, Ms. Coward. Like it was just mentioned, I've been on the Chief Justice Commission for Fairness and Equity since the end of 2020, and immediately just trying to hit the ground running and finding ways to have, our juries look more representative of the demographics of the communities of which we serve. Um, it is, I've been practicing in Wake County so long that it's just locked into to my practice as the public defender here. But things I hear across the state is that we're not getting enough people of color on juries, not a diverse background on juries, and unfortunately, the only people that are serving on juries are the people that can afford to do it. And obviously, that is not going to be fair to serve anyone. So that's kind of where our conversation immediately went to, because one of our recommendations that got approval early on, and it's not set in stone yet, but just raising our rates for juror pay. We had talked initially about our task force consists of myself, Mr. Banks, who is an elected DA, clerk of court from Greenville, and then a private citizen from Asheville. And just getting to know it, I've kind of felt ignorant when learning this finally about how our jurors get here, because the way I was experienced our jurors before is when I'm sitting there with my client, they bring that panel in, and everybody just turning around to watch them come in and making our assumptions from there and trying to figure out who we're going to want to talk to, but not knowing anything about how they got there. But often experiencing, talking to my clients who, unfortunately and systematically tend to be younger Black males, that jury rarely looks like that. That veneer rarely looks like that. And then, a lot of times in my public defender capacity, talking to them in advance before trial, saying, if we go to trial on this jury is probably not going to look like you. We're going to have a lot of engineers from Cary, a lot of people, a lot of retirees on our jury. It is not going to look like the people that, I guess, what the mandate is to be a juror of your peers. It rarely works out that way. So going forward from that, one of our concerns that I think our next step is to seeing how we can adjust the list, looking at Professor Chernoff's presentation, just getting more ideas about that, because when you're just pulling driving records and the amount of people that change their addresses normally, we have so many problems with just getting clients into court because they being in a transitional housing or being transient, those letters bouncing back, and it just becomes a matter of course. Well, the letters came back. This is who we have here, and this is who you have to choose from. So being able to expand that scope to include a broader cross section of our community, and where we ended up with our first task that it passed fairly easily is just raising juror pay. A lot of times we have people, come up and say, or they'll ask to be excused once they're once they're brought in the box, especially if they hear that a trial may last, longer than a week. I can't serve on this jury. If I may lose my job, and some people, well, you're not supposed to be able to lose your job, but they don't have to pay you. So, risking losing my job or not being able to pay my rent, especially when our judges stress how important jury selection is, how important it is that they serve on these panels, how important it is for them to do their civic duty, but we don't pay them enough to even buy lunch in downtown Raleigh at this point. So I am hopeful, and I'm fairly certain that we will get some amount of traction on that, and at the very least raise their pay to where they can buy lunch, they can pay for parking. Our committee, we're shooting high on that. I think just in the time where I was put on this panel, on this commission at the end of 2020, you also heard so much about just raising minimum wages to living wages. And then if we're still with this very important task, paying people less than that, it will make sense why people just can't afford to do it, even where they may want to. So that's where we're going with this, and had a lot of work with our commission, and got some good members there that are concerned about it because, like Professor Chernoff mentioned, I would like to think that everyone is concerned of making sure that at the end of the day, regardless of what the decision is, that they say, oh, this jury was fair.
Absolutely, absolutely. Thank you so much. That's really helpful, and it's great to know that you all are doing such great work on juror pay. I want to bring Judge Crosswhite and Ms. Prevette into the conversation to tell us about what they've seen in Iredell County. I know that back before the pandemic struck, Judge, you issued an administrative order to collect some demographic data about the jurors or the people arriving at the courthouse to participate in jury service or jury selection. And I'm just curious to hear what you've seen on the ground there around these questions of juror diversity, and if there are steps that have been taken in your county that have seemed to be helpful in ensuring that we have a representative jury.
Well, Emily, thank you for this opportunity to speak, and also personally, thank you for your help in getting that questionnaire ready. And you did mention we have Ruth Prevette. She has been our jury clerk for close to 18 years. And, you know, I think we talk a lot in theory about things, but it's actually good to have somebody with her experience to talk about the reality of what she's doing. Just to kind of let you know sort of what we did in the background of why we did it. I mean, we are probably pretty consistent with what we've heard so far in the way we do things. We get our raw list of potential jurors that come from DMV and voter registration. We get that in August. Our jury commission meets in October. We have a master list compiled by November, and then we start pulling from that list in January. And I think, like everybody said, it's been a 2-year pull, which I think has created problems. At this point, we're about 1 year into the pull. We were approached by some of our attorneys. There was a lot of talk about jury diversity, and what we needed to do with it. And the first thing that we determined was, instead of just sort of guessing, we needed to actually try to get numbers that we could put behind things. So, and Emily, that was why I thanked you. I think some of our local attorneys worked with you to develop a jury questionnaire. In January of 2019, we actually entered an administrative order that required all the potential jurors to come in, and it was a relatively basic questionnaire. It just asked for age, sex. Question number 4 asked, are you Hispanic, Latino, or Spanish origin? Question number 5, what was your race? And then today's date. So we were able to compile that with the census data that we had here to try to see what numbers we were actually looking at. And again, I realize this is a very small snapshot. This is Iredell County. I mean, kind of a mid-level county. We've got a total population by the last census of 192,000. So it's kind of, I mean, just keep in mind what it is. But anyway, just to give you the results of these numbers and where we stand. And I guess before I give you the results, I want you to understand, and you had mentioned it, we'd started doing this before COVID. Then we had the COVID shutdown. Obviously, we weren't collecting data, and then we were starting back after COVID, and we were just lucky to get enough people to have a jury in. So this questionnaire kind of fizzled out a little bit, but we're starting to do it again. And hopefully, it'd be curious to see if the numbers we get post-COVID are different than the numbers we got pre-COVID. But to let you understand kind of what some of the numbers are, we have total population in the county of 192,000. That's pretty evenly split, 50-50 male, female. The white population of Iredell County is 75%. The number of white jurors that showed up for the jury pool was 82%. So we had a 7% higher number of whites that actually showed up in the jury pool. The Black population identified as 13%. The answer of the Black population that answered the questionnaire was 12%. So that was actually pretty close. We were within 1% of the total population. The Hispanics and others, they were 12%. They accounted for 6%. So we saw I guess to summarize that, what we saw was about a 7% higher number of whites that showed up in the jury pool than matched the population. And those that identified as others, Hispanic and others, was about almost 6% less. One thing I think that we did notice that was maybe the most troubling is, you had talked a lot about these letters being returned, jury summons being returned. We tracked that number as well. We had about 11% actually returned unable to locate, which was lower than we thought. But the problem was it actually translated to, we were seeing about maybe 60% of the people that actually got letters actually were showing up for jury duty. So as a result of that, we did a couple things that were in our control to actually do. We started sending follow-up letters. And I actually think we sent 2 letters out. The first one was kind of a sort of a polite letter that said, basically, you missed your jury service. We realize it could have been an oversight, but please call us to reschedule so we could get those people back in. And then we sent a second letter that, and we were able to basically pick up a lot of people from doing that. The other thing I think we realized that we might need to do is update our jury list perhaps every more than 2 years. Like I said, we're working on a list now that's a year old. And a lot of people can move, a lot of people change addresses, a lot of things can happen in that period of time. So those were the numbers we found is the actual population we were getting, excuse me, pretty closely matched the population of the county. But what we were actually seeing that really caused the most concern were those numbers of people that were actually showing up
Right.
to serve. One thing I do want to add, and so what we've done locally, those follow-up letters have helped a lot. Having a discussion about updating our jury list more often has helped. The other thing I do want to just add to what's been said already is jury pay. If I hear one excuse more than any other, it's people are missing time from work, they're not being able to be at work, and even though that itself is not a disqualifier, lawyers are crafty enough to know how to rephrase that question, and a lot of times get a challenge for calls because somebody is not able to pay attention, their mind's somewhere else. And they don't think they can sit and listen and give a jury the time it has. So I think the 2 things I would say from a global level are we really need to look at what we're paying our jurors to get them to stay. And then we also probably look at the source list because that is kind of limited as well. But that was what
I appreciate that perspective.
Yeah,
Judge, I'm really glad to hear that the follow-up letters has proven effective at addressing some of those issues. And I certainly share your sense that increased juror pay and frequent updating of lists could be extremely helpful. I want to make sure we bring Clerk of Court Mark Kleinschmidt and DA Spencer Merriweather into the conversation before we have to wrap up. And there's so many different threads I could pursue with all of you, but I just want to bring DA Merriweather into the conversation because I know Mecklenburg County has a unique childcare program for the children of jurors. And I would love to hear about how that got underway and what impact you think it has on accessibility and inclusivity in Mecklenburg County.
Spencer, before you answer, I want to make sure that we have the opportunity to put up our CLE code. So just quickly, Randy, if you could put up our CLE code, which is B as in Batson 94198. And I'm also going to put it in the chat. Again, that's B 94198.
All right, I believe we're back. DA Merriweather, could you weigh in and let us know what impact you think it has to have this childcare program in Mecklenburg County? And with just the few remaining minutes we have, any other steps that are taken in Mecklenburg County that you think are helpful at ensuring jury diversity?
Sure, and I'll be quick. I'll just say, first of all, I'm here as a representative of my county court stakeholders. And well before I got to this office, there was an investment in the creation of a nonprofit agency, actually, to create a child care center right within our courthouse, not just for jurors, but also for people, anyone who has business in our courthouse. It has proved exponentially beneficial for jurors that come into our courthouse and are worried about, who's going to be able to take care of their kids while they have been called to do this extremely solemn duty. It goes a long way, as just hearing Judge Crosswhite and hearing Chief Public Defender Thomas talk about the different concerns people have as they come into the court system, come and go into jury service, about reorganizing their lives for the time that they're doing this service. Knowing that your child is going to be taken care of is a great thing. Certainly in this district, we have given a lot of attention to making sure that our pools are more diverse, and also making sure that our pools are coming into this service with the right frame of mind. It's the reason why probably in about, I would guess, within the next 2 months, we will begin showing the video that, Emily, that you mentioned to all of our prospective jurors at orientation, kind of raising thoughts about implicit bias in what it is that they're about to be called to do, not just for criminal trials, but for all trials. From the one, as a lone prosecutor who's on this panel, I just want to make sure that I also say it is extremely important that when we call victims and witnesses to the stand, that they are able to look over and see people who will recognize their perspectives and understand the dignity of their bodies and the dignity of their families and property as well. And so the final thing I'll say about what we try to do as an entire system is celebrate jury service and motivate people. When we go into community meetings, we talk about the fact that just as you go in to vote on election day, if you want to have a role in what your judicial system is, the jury system is the way to do that. So by providing comfort, by providing some convenience, and by making sure that we are celebrating this awesome responsibility, I think that not only the DA's office, but every court stakeholder in my county tries to do exactly that.
That's excellent. Thank you so much, DA Merriweather. Thank you for your many contributions to trying to uphold this solemn constitutional duty, and to your contributions to that video project. It was greatly strengthened by your involvement and your contributions. And I look forward to learning how it is received in Mecklenburg County. And I think that the data really bears out what you mentioned at the end, that when people participate in jury duty, they end up, even if they were, perhaps trying to get out of it on the front end, it is the way that our citizens contribute to the most important decisions that are made in our justice system. So it's the voice of the people in matters of justice, in the same way that people participate politically in the voting system. So I appreciate everything you and the other court actors in Mecklenburg County are doing to ensure that we have diverse and inclusive juries in that county. Clerk of Court Mark Kleinschmidt, I would love to hear what's going on the ground in Orange County, whether or not you have concerns around the composition of the jury pools in your county, and any steps that you're taking to ensure diversity and representativeness in your Orange County jury pool.
Thank you. Thank you for having me here today. I share the same concerns that have been expressed throughout this entire program regarding the lack of representation in jury pools, and we see it here in Orange County as it's seen everywhere else. We have committed here to joining Mecklenburg, Gaston, and I think Cumberland County, who are the annual jury pool counties. We are about to do our first well, this is the first year we've eliminated the biennium. So we like Iredell did a jury pool selection last year, and we're going to be doing it again this year. We have a big problem with undeliverable and failures to appear on jury service. And we think some aspects of the transient nature of people who live in Orange County, we can reach them more effectively if we do this every year. I'm also moved by this idea, particularly about the pay. And one reality is that if we assume that a juror who's calling, I know we can't assume this with everybody, but if we can assume that most of the folks are going to have jobs, particularly in an economy like we have today, and that their objection is that doing their jury service prevents them from being paid, there's one other truth that's out there is if they weren't doing jury service, they would be getting paid, right? So there is an employer, there is someone out there who would otherwise be paying them. And I have served in other elected offices, and I'm moved by our employers who give lip service, and oftentimes real service, to the idea of civic responsibility. And I think this is one thing that's one area of partnership that we should be engaged in. We aren't the sole party responsible for instilling and inspiring civic responsibility in people to come to jury service. An important part of that in every other aspect of American life is our business community, the people who are employing our jurors. And I have done in the past a PSA for local radio stations on jury service. I have appeared at chambers of commerce meetings and talked about the importance of jury service and how employers have a responsibility to their community to provide the opportunity for their employees to do jury service. Many of them will continue to pay. And so, having the state pay jurors, that's one way to do it. Another way is to inspire employers to continue to pay their employees when they're doing their civic duty. And, I was inspired by the professor's early slide about how small changes can have large impacts. And I don't think there's an effort that's too small that's not worth pursuing. And so that's one of the other things that I'm doing here.
Absolutely. I totally agree with that. And I think that some of what we've heard today, the changes that were made in Iredell County, for example, around sending follow-up mailings are further examples of seemingly small steps. I know they are not small. They involve a lot of administrative work. But in the big picture, they're not huge reforms, but they can have a major impact on ensuring that we have diverse, inclusive juries. There is one question in the chat. Do you have an example of a jurisdiction that should be modeled? I think that question came in before Nina got to those slides that had lists of states that had updated some of their jury formation procedures. So I don't know if Nina, if you want to jump back in and highlight any particular state that has made reforms that you'd like to point out, or if that, I believe maybe that question was answered later in Nina's presentation.
Yes, I think I would just say that many states have taken one or two efforts. And so there's not one state that's implemented all of the best practices, but we can get ideas about best practices from different states. So the key is really to identify, where is North Carolina losing jurors? Is it the pay? Is it the out-of-date addresses? And then sort of the most efficient approach is to adopt a best practice that another jurisdiction has used to resolve that particular issue.
Thank you. And I think, again, we will know more about at least one major question about the source of possible disparities in our jury pool once we have completed the study that I'm working on in partnership with UNC professor Frank Baumgardner to look at jury pools across the state. So stay tuned for more information that can help us to make sure that we are developing the right reforms to achieve the goals that we've all discussed today. I'm going to turn it back over to Monica Milton with NACDL to close us out today. But before I do, I just want to thank you so much, each of you, for contributing to today's conversation. It was excellent, and I'm inspired by all the work that is taking place around the state. And thank you, as always, Professor Chernoff, for joining us from New York and sharing your vast expertise on this topic with us.
Thank you so much, Emily. And Randy, if you could pull up our QR code for our survey. On behalf of NACDL, APA, NCSC, and RTI International, we'd like to thank you for attending our program. And I want to thank our faculty for their thoughtful contributions to this discussion. The recording for this program will be made available on our Strengthening the Sixth website, and you will receive a notification that the video and materials mentioned on this webinar are available in approximately a week. By now, you should have received a survey, which we just ask you to complete. It really helps with us developing new programming and finding out ways to give better content for you all. The QR code, you can just use your cell phone and pull up the survey. The CLE code, again, is B94198, and you will receive a CLE form to fill out and return to get your credit. So again, we want to thank you for attending and certainly thank our faculty for their contributions as well.